On the docket tonight is a case that actually took place in the middle of Derek Chauvin's trial, the man convicted of murdering George Floyd. It involves this woman. Her name's Kim Potter. Take a look at her mugshot. She was a police officer, is no longer a police officer. She was charged with the death of Daunte Wright, and we have a picture of Daunte. Daunte was driving a car, was pulled over, and during this motor vehicle stop, Kim Potter approaches the car. She's yelling, "Taser, taser, taser," trying to subdue Daunte Wright. As she's yelling, "Taser, taser, taser," you can see in her hand it's not a taser. It's her service weapon. She fires that weapon and shoots and kills Daunte Wright. I'm going to show you the whole incident. It takes less than a minute, 58 seconds of video that really will be what this trial is all about. I have to warn you again, this is graphic. We've done our best to not show you the most graphic parts, but this is what the trial is about. Take a look.
Don't. You take stuff, bro. Don't do it. Don't do it.
That's it. It's difficult, right? She's yelling, "Taser, taser, taser." Just shoots him. And that's what this case is all about. Now, some papers were filed in court. Interesting because the defense has filed a motion to dismiss count 1, which is first-degree manslaughter. Here is part of the state's opposition to that. They've written to the court that the defendant acted consciously, intentionally in reaching for and drawing a weapon which she pointed at Mr. Wright, resulting in her reckless handling and use of her duty firearm. Defendant was trained, aware of the risk of weapons confusion, but disregarded her training and experience. And they argue that the Minnesota statute does not authorize dismissal of first-degree manslaughter charge. Let me bring back in the think tank. And the question here seems simple, but I don't think really is simple, is when does an accident become a crime? Brian Watkins.
That's a tough one because there's a defense called mistake of fact. And she mistakenly, took for fact that what she had in her hand was her taser at the time that she pulled the trigger and then realized it was her service weapon. That is a mistake of fact. She did not intend to pull her service weapon and pull the trigger. So that is an absolute defense. This is a complete accident. This is what civil cases are for. This is what a civil case is. She will be liable for his death, but criminally liable, I don't believe so. There's not a murder here. There's no mens rea. She did not intend to do anything unlawful. Tasing him was absolutely lawful, as he was resisting arrest and attempting to flee. So what we got to realize here, too, is when are people going to understand that if you resist arrest, you may be seriously hurt and or killed? That's the message that needs to come from all these incidences that we're seeing.
So in regards to mistake of fact, remember that the mistake of fact has to be a reasonable one, and it's not a reasonable one in this case. We're talking about a 20-year veteran. We're talking about a person that has been working as a police officer for 20 years. The weight of the taser is different from a gun. The feel is different from a gun. The color is different from a gun. Plus, it is positioned differently in your belt that you're wearing from where the gun is. So I think it's a question of fact. That's why it's going to a jury. Of course, it's going to be a jury trial. But King Potter, she should have known better. My question is whether unconscious bias did play a role in this case.
Yeah, I don't think that unconscious bias necessarily is the main issue here. I think the issue is going to be it's easy for anyone, any of us, to sit here and say what should have been done. But what's going to be stressed by Earl Grey, excellent lawyer, is going to say seconds happened. He got in the car. He's going to show the stress of everything, and that this was just kind of a reflex situation, what we call sometimes a slip and capture. Believe it or not, this happens not often, but it does happen. This is not the first time that someone's reached for their taser and ended up shooting with a gun. Just because it's on the other side does not mean that, you gotta understand, that her gun was on the right side. She's right-hand dominated. All of a sudden, she reacts to the situation. She pulls it out under the stress and strain of that situation. It is an accident under these circumstances. And to simply say, well, the taser was on the other side. She should have known better. She should have. Yeah, shoulda, shoulda. It's easy to talk about. But put yourself in that situation at that very moment, that very second. We can't even talk moments here. We're talking seconds. And an accident is okay because this is going to be a fight over the elements. Did she create that situation? Did she consciously create the risk? Those are the elements that have to be met here. And we're talking about in seconds, that's it. No way someone was able to formulate.
But the incident didn't require a taser. That's the problem from the very beginning, because he had already been patted down. If you look at the video, look at the officer that's actually holding Daunte Wright, and he's looking at Kim Potter like, yo, why? Not even necessary. It didn't call for a taser. You know that he wasn't armed at the time, that he was getting inside of his vehicle, so you thought that he needed to be tased. The situation couldn't be controlled in a different manner.
Bernarda,
yes,
you know
he was going to
the
flee.
jury is going to debate this. They're going to hear use of force experts. They're going to hear that when a suspect or someone who's been taken out of the car goes back into the car, you may be right, he was patted down. But can you say here and now he didn't have a weapon in the car? And even if he didn't, if he's taking off, isn't he putting people's lives in danger, including the officers and any other bystander or any other cars going by? A taser is less than lethal force. The question that a jury will say is, yeah, was that reasonable? And I don't think that everyone's going to agree with you. And then the question just becomes, in grabbing for that gun, does that rise to the level of a crime, or was that an accident that does not meet the necessary elements here? And I think that good lawyering is going to show that this was an accident. I think Brian's right here. This may be a payout, but should not be a conviction.
Yeah, and the should have known question is sort of irrelevant, because the real question is what did she actually know? Did she intentionally do that? To get a murder charge, you need to intentionally act. And if she did not know, yes, she should have known. But if she, in fact, didn't know at that time, under that stress, then there's no criminal case here.
All right, folks, we've got a trial coming up. And this one, very quickly, trial date of November 30th, Minnesota versus Kim Potter.